Data protection in Italy, European law and the role of GDPR. Data protection, also called privacy protection, refers to the rules that control how personal data is collected, stored, shared and used. Personal data includes names, addresses, email addresses, phone numbers, dates of birth, bank details, location data and online behaviour. In Italy, data protection is considered a fundamental right and is strongly connected to European Union law, especially the General Data Protection Regulation, GDPR. Italy started protecting personal data early. Law 675 of 1996 was one of the first laws in Europe to regulate privacy in the digital age. This law was later replaced by the Italian Privacy Code, Legislative Decree 196/2003, which created a clearer and more structured system. When GDPR was introduced at European level, Italy updated its laws through Legislative Decree 101/2018, adapting national rules to European standards. Today, data protection in Italy is based on GDPR and national adaptations, ensuring the same level of protection across the EU. Privacy is important because personal data has economic and social value. If data is not protected, it can be misused by criminals. Stolen personal data can be used for fraud, phishing scams, and identity theft. Criminals may open bank accounts, make illegal purchases, or pretend to be someone else online. Data protection is also essential to prevent cybercrime, especially when it comes to banking details and contact information. If this data is exposed, criminals can carry out financial fraud, online scams, and unauthorized transactions. Strong data protection laws help reduce these risks and protect both citizens and institutions. Data protection laws apply to many areas of daily life, such as healthcare, employment, education, banking, e-commerce, and social networks. Any organisation that collects personal data must clearly explain what data is collected, why it is collected, and how long it will be kept. This principle is called transparency, and it helps people understand how their data is used. Two important principles of data protection are accuracy and security. Personal data must be correct, relevant, and updated, and individuals have the right to access their data and request corrections. Data must also be protected using security measures such as passwords, encryption, secure servers, and limited access to prevent hacking and data leaks. Data protection laws also prevent abuse. Data cannot be collected without a legal reason, cannot be reused for different purposes without consent, and must be deleted when it is no longer necessary. Organisations are not allowed to collect too much data, which reduces the risk of misuse. Social networks are among the biggest collectors of personal data. When users sign up, they usually provide name, email address, date of birth, and phone number. The date of birth is especially important as it is used for age verification, content limits, and targeted advertising. For example, it helps platforms identify minors or send birthday notifications, encouraging users to stay active. This shows how simple data can influence behaviour without users noticing. Algorithms play a major role in this process. They analyse likes, comments, shares, searches, and time spent online. Based on this data, algorithms decide what content users see and which advertisements they receive. Although users feel free, their experience is shaped by data-driven systems. A serious issue is lack of awareness. Many users accept long terms and conditions without reading them. By doing this, they often allow data to be shared with advertisers and third-party companies, increasing the risk of misuse and fraud. The General Data Protection Regulation, GDPR, is the main EU law on data protection. It was adopted in 2016 and became fully effective on 25 May 2018. The goal of GDPR is to protect personal data. The aim is to give individuals control over their information, and the task is to regulate data use and enforce responsibility. GDPR can limit data processing and impose heavy fines. It requires organisations to collect only necessary data, protect it securely, inform users clearly, and allow access, correction, and deletion. In conclusion, data protection in Italy and Europe plays a vital role in the digital age. While online services offer convenience, they also collect large amounts of personal data. GDPR and Italian law help prevent fraud, cybercrime, and abuse, but awareness is essential. Understanding how data is used helps people make safer online choices. Questions. Listen to the questions and record your answer on your device. Then listen to yourself speak in English. Don't like your answer? Not to worry. Simply delete and do it again until you're happy with your English. And remember, practice makes perfect. What is data protection? 2. What types of information are considered personal data? 3. Which Italian law first regulated digital privacy? 4. How did Italy adapt its laws to GDPR? 5. Why is personal data valuable? 6. Name 2 risks caused by weak data protection. 7. What does transparency mean in data protection? 8. What are 2 main principles of data protection? 9. Why is date of birth important for social networks? 10. When did GDPR become fully effective? Guess game questions 11. Why might criminals prefer stealing personal data instead of money? 12. Why do many users accept terms and conditions without reading them? 13. How can algorithms influence user behaviour? 14. Why is banking data especially sensitive? 15. Why does GDPR apply across all EU countries? 16. Why is deleting unnecessary data important? 17. How could better awareness reduce cybercrime? 18. Why might companies collect more data than needed? 19. Why is security as important as accuracy? 20. How does GDPR give people more control over their data?